Court appeal is for an internal arrangement of the court and not to be considered as a substantive separate appeal?
My Lord, this is a question which to a certain extent has been answered by an opinion of Justice Munib. And I'll straight away come to that. Those are three. There is a short order by Justice, it is Justice Mandokhail who actually raised this very important issue through a short order. And then there are two opinions, one by Justice Hassan Azhar Saab, one by Justice Munib.
You might consider these three judgments of the Lahore High Court
yes,
also,
I can. But let me just read those because those are actually with reference to this particular case, if I may come to those judgments. And those deal with both issues, one of competence of appeal and intra-court appeal. Both have been dealt by the two separate opinions. If your Lordship will kindly see page...
that was without my opinion. Without my opinion.
लेकिन सर आपके सवाल की वजह से डिबेट शुरू हुई. आप सवाल नहीं पूछते.
Actually, this should have been that I should have been asked what is your opinion. Without my opinion, it was said to me.
लेकिन सर आपके खिलाफ जवाब देके भी आपके हक में जवाब दे दिया वो देखिएगा आप सर पेज 9 पे.
चलो मैं उसका जवाब अभी जो खत्म हो गया तो उसमें दे देंगे.
Sir, page 9 of the paper. Now, these are three unreported orders, my lord, but I think these are such crucial orders should be. If I may first to Justice Mandokhail's very interesting question, which he's been constantly raising in these proceedings. If I may come to page 9, and I'll read from the second paragraph, para 2, fifth line. The question which needs consideration is whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect of matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution. Reference is made to the order dated 13/4/2023 passed in Constitutional Petition 9 of 20. This very petition, relevant portion whereof is reproduced above. I'll leave the portion, I'll read the last 4 lines. As the issue involved is in this petition is identical to the issue involved in constitutional petition number so and so, therefore let it be placed before the Honorable. Now, on this, a dissent was done by Justice Hassan Azhar. Very interesting opinion, my lord, page 12, if your lordship may kindly see. Now, the main thrust of this opinion is on that this question did not arise in the case. That is why the case was really decided on the merit. There's a very important paragraph on this intra-court appeal, which is at page 17, para 14. It's the same content. It is the same line of argument which Justice Mazhar had alluded to yesterday. Para 14, page 17. As far as the question of whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect to matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution is concerned. So both constitutional forums, intra-court appeal in the law reforms order. I am of the humble opinion that Article 175 of the Constitution by its clause 1 ordains that there shall be a Supreme Court of Pakistan and a High Court of each province and recognizes that such other courts as may be established by law. Clause 2 of that article provides that no court shall have any jurisdiction save is or may be conferred on it by the Constitution or by or under any law. For the above question, it is sufficient to say that the Supreme Court of Pakistan and the High Courts have been established by the Constitution, that they have such jurisdiction as has been conferred upon them by the Constitution, that they have also such other jurisdiction as is or may be conferred upon them by or under any law. The expression law here has been used to distinguish it from Constitution, which is higher in authority and obviously means an ordinary or sub-constitutional law made in the exercise of the powers granted by the Constitution. Reference in this regard may be made to the judgment of this court in the case of Brother Steel Mills Limited versus Mia Ilyas Miraj, PLD 96 Supreme Court 543, wherein the provision of section 15 of the Code of Civil Procedure Amendment Ordinance 19 80, which also provides a right of appeal to a bench of 2 or more judges of a high court from an interlocutory order made by a single judge. That court, in the exercise of its original jurisdiction, has been interpreted by a 5-member bench of this court. Even otherwise, no provision of the Constitution places such bar on the power of the legislature. Both under 199 and 184.3, there is no bar that a right of appeal through a statute cannot be provided. Now, your lordship may note 2 things about it, and I'll come back to this. The first is that legislative competence here has been placed on Article 175(2). That's the first thing. Number 2 is that it has been held that even if the order is from a constitutional forum, as Justice Mandokhail had pointed out, even then an intra-court appeal can be provided through an ordinary statute. Now, it's very interesting how Justice Munib deals with this, because he extends the notion of legislative competence and agrees with Justice Hassan Azhar Rizvi on the issue of the law reforms ordinance. Page 20.
As a referee judge.
Ji?
As a referee judge,
Sorry? Referee judge, sir. Page 20, sir. I may read. Para 3 measure of context de do. On hearing the matter, a different opinion arose between the learned members of the bench on a point that was, it appears, framed by Jamal Khan Mandokhail, his lordship, expressed doubt whether a right of intra-court appeal could be provided by ordinary statute, like the ordinance against a decision of a single judge of the High Court, exercising jurisdiction under Article 199. Reference was made to certain pending petition filed under Article 184(3) of this court. Now, let me come to para 4. A difference of opinion has, next page, has arisen in my view. The question of law requiring resolution is as follows. Can the appropriate legislature provide by ordinary statute for a right of appeal against a decision of a single judge of a high court exercising jurisdiction under Article 199 of the Constitution, such that Section 3 of the ordinance is a valid legislature? Now, as far as where does legislative competence come, or how is appeal in terms of legislative competence to be framed? Very interesting paragraph, para 9, page 23 of this opinion. If I may read kindly from the last line. One is a right, I move to the second page, that is relatable to a specific entry on a legislative, this is the next page, 24, or to a particular legislative
I may request you kindly start read the whole.
Should I read the whole, sir?
I think
Ji,
that
ji,
may
ji, ji.
provide
But,
some-
ji, sir, ji, sir.
Some background.
But of course, the ordinance was not just an amending statute. It also had Section 3, which provided as presently relevant for a right of intra-court appeal in terms as noted above. That also had to be taken into account while determining its spirit and substance on the commencing date. I begin by noting entry number 46 of the concurrent list. This provided in material part the legislative competence of jurisdiction and powers of all courts except the Supreme Court with respect to any of the in this list. All courts, including the High Court. Right of appeal can, for present purposes, be divided into 2 categories. One is a right that is relatable to a specific entry on a legislative list or to a particular legislative competence. The other is what might be called a general right of appeal. Now, these are crucial lines. Now, it is well settled that a right of appeal is a substantive right, which must be expressly conferred. However, jurisprudentially, appeals in a general sense are regarded as a part of procedural law. In my view, this categorization is relevant for purposes of legislative competence insofar as a general right of appeal is concerned. Such a general right would lie in the legislative competence relating, as the case may be, to civil or criminal procedure. This conclusion is bolstered by the fact that both entries relating to criminal and civil procedure, number 2 and number 3 respectively, included therein all matters included in respectively the Criminal Procedure Code and CPC. Thus, entry number 3 provided in material part as follows: Civil Procedure Code and all matters included in the Code of Civil Procedure on the commencing date. The two codes of course contain specific provisions by way of general rights of appeal. It may be noted that the context here is legislative competence. Therefore, what was relevant was not the type of appeal encoded in the Criminal Procedure Code and the CPC, but rather the categorization thereof in terms of their nature. Thus, a general right of appeal was included in the legislative competence conferred by these two entries of the concurrent list, my lord. So, what seems my reading is that as far as legislative competence is concerned, when you're looking at entries, then it is not a presumption that the competence to have a law on appeal would fall within a category which does not deal with procedure. It can deal with procedure. At least that is what it's saying.
Mr. Faisal, and I think that is echoed, you might not have looked at this, but I found 53 Lahore, 284, and it's a DB judgment, and I just read this paragraph, which is important.
I found it very interesting, but I may be misreading
Which
it.
actually talks about exactly something like this, which needs to be discussed, which is a letters patent appeal is not really an appeal in the strict sense. It may be more aptly described as an internal arrangement of the court for reviewing its own decision,
Yes,
given in the first instance by one member of the court. The first as well as the second decision remains the decision of the court. And if you look at Order 5, Rule 2 in the rules,
yes, there's a chamber appeal.
There is a chamber, it doesn't say appeal, it says for reconsideration to a 3-member bench. So three judges, if you see Order 5, Rule 2. So, I mean, before going into 55, let's sort this out whether at all this could form part of having an intra-court
So, no,
appeal.
Rule 3, Order 5, Rule 3 says appeal. Rule 3 says an appeal shall lie from registrar in all cases to
As registrar,
from
agla pade na.
to the judges in chambers.
That's
It's an
right.
appeal.
And then there is from a single judge to 3 judges.
Administrative order, and that's an administrative appeal.
But it's still an
Not
appeal.
a judicial order.
It's still an appeal and it's framed under 190.
Fair enough. I mean, it probably has a color, rightly said by my colleague, that it could be administrative in nature, but we need to understand the context. If you look at Order 5, Rule 2, it talks about the power of the court in relation to power.
In relation to the following matters may be exercised by a single
Can
judge.
you tell us where are you reading from?
Order
Sir,
5,
Rule 2, Order 5, sir, Supreme Court rules.
the power of the court.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of any aggrieved party by a bench of not less than 3 judges, which may include the judge who dealt with the matter. Your Lordship is right.
It refers to reconsideration. We don't know where to slot it. It is probably administrative in nature also. But what I'm trying to say is that intra-court appeal under these 3 judgments that I've looked at are talking about it is an internal setting and a procedure and arrangement and not considered to be substantive in that sense, which has been echoed elsewhere also. Yes. So whether at all it becomes part of a procedure of practice and procedure rather than as a substantive.
I think this note opens up that question. If I may just read the last paragraph and then Your Lordship. Sir, as far as Justice Hassan Azhar Rizvi's opinion, which basically dealt with the merits of the case and a paragraph on the intra-court level. There's a paragraph in Justice Munib's opinion on that, which is also very important. If Your Lordship may kindly see page 25, para 12.
Para 12.
Ji sir, ji sir.
Ji.
Page 25. In view of the above discussion, I am in no doubt that the question referred to me ought to be answered in the affirmative. It is so answered accordingly. I also agree with my